Good morning.
Good morning.
For some reason, I can't hear you.
You can't hear me?
I can hear you, yes.
Okay.
Thank you. Yes, good morning. Can you hear me, Miss Oswood? Good morning, Madam DPP.
I can. Good morning. Can my lady hear me?
Yes, thank you very much. Ms. Oswood, you can read the court heading. Thank you.
Wednesday, the 14th day of July 2021, court via Zoom at 11:30 a.m. before the Honorable Justice Deborah Williams, Appellate Jurisdiction 2020, number 33. Fiona Miller, Police Sergeant versus Ryan North, Miss Cindy Clark for the appellant.
Thank you. Yes, good morning, Ms. Clark.
Good morning, my lady. This is an appeal under Section 6 of the Criminal Appeal Act against an order for payment of costs.
Yes.
We did file written submissions, my lady. I hope they've reached your desk.
They have, thank you.
I'm grateful. So if I can just go through those, I don't imagine we'll take much time this morning.
Thank you.
My lady, the order for costs was made on the 4th of December, 2020, on the application of counsel for the respondent. The brief facts, as I mentioned, were that it was a disclosure and directions hearing, so it was not a trial date. There were 2 matters that were before the magistrate, and on that particular occasion, the magistrate, one of the matters, which was the speeding matter, 20 TR 02723, was we offered no evidence in respect of that matter, and the second matter was set for trial. Upon hearing the respondent's request for disclosure of a witness statement that was supposed to be part of the speeding matter, the prosecution indicated that we would not be relying upon that statement and we did not have it ready for disclosure. It's our submission that at that point, the issue was in relation to non-disclosure of unused material in respect of the impaired driving matter. And at that point, the senior magistrate then heard submissions on costs for not providing that witness statement. So in essence, the rationale provided for the order was that the court wished to register its concern about non-disclosure. And that's in the record at page 9.
Yes.
Lines 14 to 15.
Let me just mark that, please.
I marked my line just to make things a little easier. So page 9 is the ruling of the magistrate. It's not long, perhaps I can read it into the record for the purposes. It says, Mr. White submits that the defendant should be awarded his costs for the 30th of November 2020 and the 4th of December 2020 on the basis that the statement of the witness for the speeding offense, 20 TR 03723, had not disclosed his statement. On the 30th of November 2020, Mr. White put the court on notice that he would make the application today if disclosure is not made. Ms. Fiona explained that she was not aware of the cost application they made, and from her notes, she cannot say why the statement is not available. The speeding matter is a simple one and would have thought that the statement would have been easily available, especially since it had been since 27th of October 2020 that a not guilty plea has been entered. The police must do better. The required statement on the face of it would be a simple one and surely would not take a lot of time to put together. The fact that it is not done portrays a nonchalant attitude towards keeping the wheels of justice moving at a reasonable pace. This cannot take place, and if the court is able to register its concern about non-disclosure, it shall do so by way of a cost order. In the circumstances, I will accede to the defendant's application for costs, but not for the entire time that he requests, as some of that time would have been in respect of case number 20 TR 03671. I therefore grant costs to the defendant for 1 hour of Mr. White's time as taxed or agreed. So, my lady, that is the basis upon our submission why we say that the rationale for ordering costs against the Crown was because the court wished to register its concern about non-disclosure.
Yes.
The learned magistrate did not purport to make the order under any provision in law. So I did then lay out what options would have been available. The first option would have been under the Criminal Jurisdiction and Procedure Act, Section 58, which I did also provide to the court.
Okay, just one moment. I like to look at it electronically for my zooming pleasure, I suppose. Just one moment. I had it up a moment ago. Let's see it. Yes.
So Section 58, my lady, says, when a charge is dismissed and appears to the magistrate's court to have been unfounded, frivolous, or made from any improper motive, the court may award a cost or any part of the cost to be paid by the informant, either forthwith or within such time as the magistrate's court may allow. So, my lady, with respect, my first submission would be the charges in the speeding case were not dismissed, they were terminated by the prosecution. And even if the court is not with us on that occasion, because I know that that hasn't been argued fully in any other appeal, but if you're not with us on that submission, we would then submit the learned magistrate made no inquiry as to whether the speeding count was unfounded, frivolous, or made from any improper motive. And in reliance on that, my lady, I did provide the case of Cox and Butterfield.
Yes.
It's a Supreme Court appellate jurisdiction matter that was heard by your Sister Justice Simmons in July of 2008.
Yes.
It was a similar appeal under Section 6 of the Criminal Appeal Act.
Mhm.
And similarly, the sole ground of appeal was that the order should not have been made. And when that was particularized, Mr. Mahoney, who argued on behalf of the Crown, indicated that he was particularly arguing whether costs were awarded according to statute, in particular with any or adequately stated reasons. And we find ourselves in a somewhat similar circumstance, lady. So the facts of that case was the Crown offered no evidence in respect of a domestic violence matter where a complainant had withdrawn her complaint. And if we look on page 2 at paragraph 9, the Court of Appeal said, thereafter followed more than a 30-minute discussion between the senior magistrate, Ms. Deal, and Mr. Dowdy concerning the issue of the Crown offering no evidence. The earliest date at which the police were aware that they would not be in a position to offer evidence, and the issue of cost. At the end of the discussion, the senior magistrate dismissed the information and made the order for costs in Mr. Butterfield's favor pursuant to Section 28(2) of the Summary Jurisdiction Act 1930. And if we look at paragraph 14 on the same page 2, there's a subtitle, whether any or adequate reasons were given for awarding costs. The court went on to say, the power in the magistrate's court to award costs against an informant insofar as relevant is set out in Section 28 of the Summary Jurisdiction Act, and I quote to say it has the exact same wording as our now Section 58 of the Criminal Jurisdiction and Procedure Act. When a charge is dismissed and appears to the court to have been unfounded, frivolous, or made from any improper motive, the court may order the costs or any part of the costs to be paid by the informant, either forthwith or within such time as the court may allow. And if the costs are not paid by the court may commit the informant to prison for a term not exceeding 10 days unless such costs are sooner paid. If we look over the page, my lady, looking at paragraph 17, the last 3 lines, all the section requires that the magistrate consider all of the relevant facts, including the submissions of counsel, and if in his judgment the facts warranted, he may, in the exercise of his discretion, make an order as to cost. Skipping down to paragraph 19, it says, what is more to the point of law raised on this appeal, however, is Mr. Mahoney's cogent argument that the magistrate failed to adequately or at all state what his reasons for his decisions were. The senior magistrate mentioned one of the 3 criteria in Section 28, that being unfounded. However, he did not go on to state which facts, if any, satisfied that criteria. If we look over the page at paragraph 27, the court says, Mr. Dowdy for the respondent contended that even if the central reasons for the decision to award costs is not readily apparent from a discussion or decision of the magistrate, the assistance of counsel can enable an appellate court to identify the issues and follow his reasoning. For this, Mr. Dowdy relies on English versus Emery, Reinbold, and Strict Limited. In the English case, it was held that Article 6.1 of the Convention for the Protection of Human Rights and Fundamental Freedoms in English domestic law required the reason for an award of costs to be apparent, either from its reasons or by inference from the circumstances in which costs were awarded. It was further held that unless the reason for the cost decision was clearly implicit from the circumstances, the judge should explain, albeit usually briefly, whilst he made the order, that in practice it was only where an order was made with neither reasons nor any obvious explanation for the order that it was likely to be appropriate to give permission to appeal for lack of reason. I pause my lady to say, we are in a circumstance where we have a reason from the learned magistrate, but it is not one that I say is known in law. So if the court is minded to consider that perhaps what he had in mind was an order for costs under the Criminal Jurisdiction and Procedure Act, we would then rely upon the fact that he didn't provide any reasons under that section.
Okay. Are there any other cost provisions outside of the Criminal Jurisdiction and Procedure Act which you might have operated under?
Yes, my lady. So the second that I brought to the court's attention is under the Criminal Code, and there's a section 556, capital A.
Okay, one moment. $556.
56, capital A.
Okay. Yes.
Similarly, that says, in any criminal proceedings, the Court of Appeal, the Supreme Court, and the Magistrates Court may order the barrister and attorney or other representative concerned to meet the whole of any wasted cost or such part of them as may be determined in accordance with rules of the court. And I think I may have to read this whole section. In subsection 1, wasted cost means any cost incurred by a party as a result of any improper, unreasonable, or negligent act or omission on part of any barrister and attorney, representative, or any employee of a barrister and attorney or of a representative, or B, which, in the light of any such act or omission occurring after they were incurred, the court considers it unreasonable to expect that party to pay. Subsection 3, an order made under subsection 1 may be made on the court's own motion or on application by any party to the proceedings to which the order may relate. An order made under subsection 1 may be appealed to the Supreme Court where it was made in the Magistrates Court or to the Court of Appeal where it was made in the Supreme Court, and no further appeal from a decision made under subsection 4 may be permitted. It goes on to say, in this section, representative means a person other than a barrister or attorney or a prosecutor permitted by the court to represent an accused person in court proceedings. That's the only other provision in my submission that the court may have had in mind when he ordered costs in this case. But then we also did provide a case validity of the Crown and Worrell.
Yes.
And that is a Court of Appeal matter, my lady.
Yes.
Again, an application for costs was made by the respondent, Mr. Worrell, against the Crown in a response to him being discharged on the basis of a no case to answer in the Supreme Court after trial. If we look, my lady, in the judgment at paragraph 5, and I should say the whole issue was whether or not the Supreme Court could actually order costs against the prosecutor in those circumstances, and whether the court had to use its inherent jurisdiction or whether it could use 556 capital A.
Okay. Thank you. That's helpful.
Thank you. So looking at paragraph 5,
Yes.
it says, as to the statutory power, we were first referred to the Criminal Code Act 1907 as amended. Section 555 makes provision for the payment of costs by a private prosecutor. There is, however, no comparable provision for the payment of costs by the Crown. Section 556 provides for what is to happen when an order for costs has been made. It is procedural and does not itself confer any power to order costs. Section 556A provides for wasted cost orders against barristers and attorneys. The section is, however, dealing with individual representatives rather than the Crown. In any event, it is not a case involving wasted costs. The fact that the code makes provision for the payment of costs against a private prosecutor, but no provision for the payment of costs against the Crown, strongly suggests that there is no such power. Further, if there is such a power in the Supreme Court and the Court of Appeal, it is surprising that there's no indication of it ever having been exercised. So that's speaking about whether or not 556. If we turn over the page, my lady, to paragraph 10, the Court of Appeal deals with the Supreme Court's inherent jurisdiction, which we know the Magistrates Court doesn't have. It says, it would be surprising if the court had no jurisdiction to make an order for costs against the Crown, whatever the circumstances. And indeed, Mr. Mahoney accepts that the court has inherent jurisdiction, although he submits it should be sparingly exercised. In Berry versus British Transport Commission 1961, 3 All England reports at 65, Lord Justice Devlin pointed out that in criminal cases, a successful defendant had no prima facie entitlement to an award of costs as the prosecution was brought in the public interest. He said at page 75, a plaintiff brings an action for his own ends and to benefit himself. It is therefore just that if he loses, he should pay the cost. A prosecutor brings proceedings in the public interest and so should be treated more tenderly. Mr. Hudson argued this appeal strongly relied upon an English direction, but the court isn't with him on that point. If we go down to paragraph 14, the court says, in my view, assistance is to be found in the Canadian authorities, in the Crown versus Robinson, in a 1999 Canadian appeal case. Justice of Appeal McFadden said in paragraph 29, while costs may be awarded against the Crown in the exercise of the court's general jurisdiction, the clear rule has been that such costs will only be awarded where there has been serious misconduct on the part of the Crown. Sorry, my pages are sticking together. It goes on in the case of Pulaski and also Berry and the British Transportation Commission. The reason for limiting costs are that the Crown is not an ordinary litigant, does not win or lose criminal cases, and conducts prosecutions and makes decisions respecting prosecutions in the public interest. In the absence of proof of misconduct, an award of costs against the Crown would be a harsh penalty for a Crown officer carrying out such public duties. More recently, in the case of Tremble, the Ontario Superior Court Justice Fragomini said, "I am not satisfied that the Crown has engaged in any conduct that would merit sanctions in the form of an award of costs against the Crown." The Crown appeal was unsuccessful. Although the appeal was unsuccessful, I cannot say that in the proceeding with the appeal, the Crown acted in any improper way. The Crown was unable to persuade this court that the London trial judge erred. However, there is nothing to support a finding that the Crown's conduct was improper, oppressive, or high-handed. It is true that the Tremble case was a case involving a statutory provision entitling the court to make any order with respect to costs it considers just and reasonable, which we don't actually have. However, its importance is that it emphasizes the high threshold that must be crossed before a successful lieutenant can recover his costs from the Crown. So
that's a binding position on this court in any event. This is a Court of Appeal decision.
Yes, my lady. So this Court of Appeal is of the opinion that 556A, it only speaks to 556A, doesn't necessarily apply to a prosecutor unless there is.
But it puts a turn on the provisions under the Criminal Jurisdiction, Procedure and Jurisdiction Act in any event. That's how I would read it.
That's correct, my lady.
Sorry, I just want to go back to section 58 for a moment under the Criminal Jurisdiction and Procedure Act. One moment. Yes, thank you.
I'm grateful. So, my lady, it's our submission that the Disclosure and Criminal Reform Act doesn't give any provision for ordering costs if there's a fault in disclosure. What that act sets out is a regime where the court can order the prosecution to make disclosure by a certain time and thereafter consider a stay of proceedings. That is where the magistrate should have gone. But even in the fact of this case, the Crown offered no evidence. So I don't see the basis upon which you're trying to punish the Crown for, in fact, making a decision to offer no evidence before a trial is fixed.
In offering no evidence, can it not be said that the charge would have then been dismissed?
Well, that's not an argument I was prepared to have with my lady in this particular case, because in my submission, it isn't necessarily a relevant issue that you have to decide. But in my submission, offering no evidence is the Crown terminating a prosecution. I don't believe that the court necessarily has to dismiss.
But once something has to be done with the charge.
Well, we've offered no evidence on the charge. I would submit that when you have a situation where, yes, he's entered a not guilty plea, we have said that we are not offering any evidence, then the information is dismissed, but a defendant is discharged.
The information is dismissed and the charges on the information can be said to be dismissed.
Well, my lady, like I said, I would relish the argument on the separate case, but I don't necessarily agree with that. I believe charges are dismissed upon adjudication. So, for example, if you had a trial and you had more than one count, you can dismiss a charge because you find insufficient evidence to prove, but you can also find guilty on a second count. But dismissing an information, I would submit, is a different thing.
But I mean, even if I'm not with you on that point, which may very well be technical, your overarching argument is that when it comes to cost orders against the Crown, you really are proceeding against the background of the comments made by the Court of Appeal and the case law that the Court of Appeal approved.
I am, my lady.
Judgment of Worrell.
Yes.
Okay. One thing is bothering me. Tell me, what was contemplated in relation to appeals under Section 6 in terms of who might respond to it? Because you're unopposed in your arguments.
Yes.
I mean, is that what was envisaged under Section 6? What would be the interest of anyone?
No, I wouldn't have thought so. I would imagine that it was envisioned that the person who asked for the cost would seek to argue against on the appeal. But in our case, Mr. White had indicated that he would not be opposing.
But that's not likely to be a general position.
I shouldn't think so, Melody. I mean, in this particular case, it was only an hour of his time, so perhaps he didn't necessarily consider it feasible or worthy of the cost.
So
But
I mean, by contrast, for example, in the case of Worrell, that argument was Mr. Mahoney was opposed by Mr. Worrell, whoever represented Mr. Worrell. Is it Mr.?
I believe Mr.
Hudson?
Hudson, yes, from
Yeah.
Apex, appeared for
Okay.
Mr. Worrell.
All right. I ask only because I obviously should consider whether or not there is an order available to the court or an order that should be made in terms of the other side being argued before me this morning, but I'm not sure it would be appropriate for anyone from the Attorney General's chambers.
Probably not, as the
Yeah.
interests
I
aren't
mean, this is
necessarily
written under the
magistrate.
Criminal Appeal Act, so I think it's a question as to whether or not the respondent wants to be heard or not. Okay,
That's correct, Melody.
all right, thank you.
you.
Unless you want to add anything further to that, I thought that was very helpful.
I'm grateful, Melody. Unless I can be of any further assistance, those are my
Yeah.
submissions.
Obviously, I'm going to reserve and give a written decision. I hope not to be delayed on that. I have a few decisions to write, but I think I'll still come within the 6-week period. Okay,
I'm grateful. And if my lady is minded, the only other thing I would add is that apparently these types of orders are coming fast and furious in the magistrate's court. So I would appreciate
put it in front
presiding.
of my line.
No, I'm not asking to take priority. Just because I know my lady would write a rather thorough judgment. I'm just
Yes.
hoping that my lady
Okay.
keeps with her habit of writing a thorough judgment.
Yes, no, I will look at it carefully. Thank you.
Thank you, my lady.
All right, thank you very much, Ms. Clark. Case adjourned.